It please your lordship. I'm Beckman. So with the consent of the other side, Beckman, item number 7, your lordship. I'm appearing on behalf of Advocate S. Bothaku, your lordship. I'm appearing on behalf of S. Bothaku, your lordship. They are good for the respondent, your lordship. Both Mr. Bothaku and Mr. Roy out of Kingston. They seek an explanation of 1 day, your lordship. The matter may be fixed day after tomorrow for hearing.
What is the matter about?
What is the matter is about description of LPG retail outlet.
Is a stay order operating?
No, your lordship. That has been fixed.
We'll have it legal at the request of the Union Council for hearing on behalf of the respondent. Matters can be adjourned to be listed on 4th of February 2025.
Assessment or leak.
There are other foods.
I get to mention item number 26.
Item number?
20.
Yes. Tell me. Huh?
Conduct council Mr. Sarabai is like
Who is not there? S.R. Rabha. What is the matter about?
NOC. Cancellation of NOC.
Huh?
Cancellation of NOC.
The council, I can't hear you.
It is regarding cancellation of NOC.
Cancellation of
NOC.
NOC for what?
Guest house.
Yes, sir. You are for the respondent, petitioner, enjoying a stay.
Yes, there is. Yeah. This interim order is there. Interim order is
They adjourn it, but no extension of the stay. Okay, at the request of the Learning Council for the petitioner, matters can be adjourned to be listed on 8th of January 2020.
item 1 to 5.
Where before? My knowledge about the start is apply to the argument. They have faced the written argument. In the affidavit, notice filed by the 1 to 3 has already. Then the region.
So as per your written argument, there is a mining lease.
Hello. The mining lease was not as in terms of the sex 5(2)(b) of the section. Provides that prior to and mining lease, there should be a plan is required to be approved. That was not left in the section.
Are you saying that there is a mining?
Well,
Are you saying that there is a mining lease?
so that is not a valid mining lease. That is the region model. Prior to the mining lease, the plan is required to be there.
The Saitya has argued two aspects.
Well,
The mining lease deed is bad
well,
because of the fact that there has been no compliance to 710. But however, as there is an order being passed under 7.6, it is a mining lease. Therefore, the question is whether it is a mining lease. Because if it is because there are two parts of your order. The first part says that the mining lease could not have been granted in view of the fact that there was no mining plan or whatever, maybe there has been no compliance to 710 or something. But the second part says that in view of the proviso to section 10(2)(a), B, 10(a) to B, it has lapsed.
well,
The counsel for the petitioner has been arguing one thing, that it is a mining lease, and as such, it could not have lapsed. So therefore, my question is, whether there was a mining lease, because if it is a mining lease, then it could not have been lapsed. Maybe wrongly given, that's a different thing. But whether it is a mining lease or not,
well, my consumption losses, our stand in the order as well as this affidavit is there. The mining is without the plan cannot be executed. That cannot be termed as a mining is in terms of this.
there are two aspects. Therefore, he's saying mining lease deed cannot be executed. There is no quarrel. He agrees to that. But he says that the grant of a mining lease is a mining lease itself. And as such, it is in compliance to 7.6. That is the submission of the counsel for the petition. Isn't that, Mr.? So therefore, I'm asking you, is there a mining lease?
Another aspect of the matter is
Because your argument shows that it is, they presume that there is a mining lease. May not be a mining lease. These are two mining lease.
in terms of the amendment.
Because you have no power
Hello.
to set aside a mining lease, which you have also stated.
Hello.
You can only set aside a mining plan.
Hello.
That is your thing.
Hello.
But the fact that there was rightly or wrongly a mining lease being granted and no action has been taken by them in respect to the mining lease, under such circumstances, you had no jurisdiction to decide as regards the mining lease, as well as the or say anything as regards the mining lease, or invoke the proviso to section 10(a). That is their submission.
The protections as contemplated by the petition. If these was like, that's again, rightly or wrongly, 21/1/2021, 29/1/2022, and it's a. Well, subsequent to that, on 28/3/2021, the amended provisions is coming to play. Once amended provision is came out, so those provisos under which those their claiming protection that have already been omitted, the deleted. So there, that is no longer there. That is my policy.
Yes.
Yes. So I don't think that
they have made any submission regarding the jurisdiction. So now, the facts are well laid before this honorable court, either from our side or from the other side. And Lordship has also extensively done the requirements to know the facts. So today, I would like to sum up my whole submissions. There will be 5, 6, 7 themes of arguments. And also in each theme, Lordship, there are subcategories of my submissions. So if I can give a written version also, that will, because but I am making the submissions from my written part. That will be convenient for Lordship. And we'll give a copy to the other side also. I cannot make FOMO unhappy, Lordship. And then which was return it loss. So, Lordship, kindly first, my first limb of argument is absence of jurisdiction of IBM. So, IBM has a statutory role, and it is a technical body charged with ensuring scientific mining under the MMDR Act and the rules made thereunder. The role of the IBM is very clearly mentioned in Chapter 5 of the NCR 2016, and IBM's website also has prescribed and unambiguously acknowledged the IBM's regulatory functions, which are restricted to approval and implementation of the mining plans with a view to ensure scientific and unsustainable mining. So from that point of view, I am placing Lordship the functions of IBM as they have placed it in their website, official website. If Lordship is pleased to take that the printout from the website, functions. The objective of the IBM is to promote systematic and scientific development and optimum utilization of mining resources of the country, both onshore and offshore. And in order to achieve this objective, the Charter of Functions of Indian Bureau of Mines are as follows: to collect, collate, and organize into database all information on exploration, prospecting, mine, minerals in the country in the shape of National Mineral Information Repository, and take steps to publish and disseminate the same. Function as the national technical regulator, which is I am highlighting lot. 3, to build up capacity in the system, both as regulatory as well as developmental work at the central level as well as at the level of the states. To establish institutional mechanism of coordination between the center, states, mining industries, research and academic institutions, etc. Then 5, promote research on all practical aspects of the mining part, to provide technical consultancy services, to participate in international collaborative projects, etc., to advise government on a matter relating to the mineral industry, to undertake any such other activities as has become necessary in the light of development in the field of geology, mining, mineral beneficiation, and environment. Basically, these are highly technical area where they have to apply their expertise. All the links are here. And Lordship will kindly come to after 9. Please click here for detailed functions and activities of Indian Bureau of Mines and activities of Indian Bureau of Mines. So in the website, everything is included and it can be seen by clicking of a particular link. Nowhere there is a power or function given to there is any role of the IBM to monitor the grant of mining lease by a state authority or by a central authority. That power is not given to them. They cannot give any opinion regarding the opinion on the mining deed lease, which they have expressed in the first part of their impugn order. Those are beyond their jurisdiction. And if Lordship is pleased to come a few pages, the same dossier, third last page, key activities and functions. In the light and role and charter of IBM, the key functions being informed by IBM can be broadly classified as regulatory, developmental. So, two major areas where they can operate is the regulatory activities and the developmental activities. So under regulatory functions, mining plans, mining regulations, etc., where in the mining plans, they have said inspection and approval. No revocation.
But
Rule
what
13
happened?
to 17 of chapter
Mr.
5 of
Paikya,
the
what happened? When there is a term mentioned in the mining plan or the approval that they can revoke.
they can revoke in one conditions that they have added, that if there is a misrepresentation on our part or
That is
submission
fine.
of
For 6.
number 6, if there is any violation with any other acts. So any other acts will not include MMDR and the rules. Any other acts means the environmental law, pollution law, any other law, forest laws, the local laws, judgments of the Supreme Court, the laws enunciated by the honorable courts. If we can straightway go to that part, Lordship, that clause, because they have taken recourse to
The
this
approval
clause,
conflict with any other law or
any other law. Very clearly says 205. First part at clause 5, Lordship will kindly see and 1. Let us go first 1. The mining plan is approved without prejudice to any other law applicable to the mine area from time to time, whether made by the central government, state government, or any other authorities, and without prejudice to any order or direction or from any court of competent jurisdiction. This mining plan has been issued in terms of the rules and the Act of Mines and Minerals. So they have complied with all the regulations as well as the provisions of the mining rules and the Mining Act. In what situation they can interfere now is that the mining plan is approved without prejudice to any other laws. Any other laws. That means not MMDR and the rules made therein.
can these terms be treated in like a
Lordship.
statute? Can these terms be treated as if like a statute?
This particular condition.
Can it be used?
We are whether it can be acted as a statute or not, but what they have said that we are issuing this, but it should subject to fulfillment of all other laws. Yes, Lord. If we go to 7, that rule. Yes. Because once the mining plan along with other things also, when the mining plan will be actually implemented, only after getting the mining plan from the state government and fulfillment of the conditions as indicated in Rule 7, Sub-Rule 10, ABCD. And ABCD says, A says, obtain all consents, approval, permits, no objection as may be required under applicable laws for commencement of the mining operation. B, provide a performance security. C, satisfy the conditions in respect with the mining plan. So suppose a mining plan is given and we do not follow any other laws which are applicable for starting the operation. In that situation, Lordship, the mining plan, it will not become operative. But if the clause is there, that clause 1 in the mining plan approval of 12 August 2021, the mining plan is approved without prejudice to any other law. So it is not affecting any other law applicable to the mine area from time to time, whether made by the central government, state government, or now, what is their clause? In what situation they can apply? If there is a violation of any other applicable laws. In the instant case, what they are saying that the approval was given as because certain procedural things under MMDR Act and rules were not followed, according to them. It is not that we are violating some other laws. What they are saying that there should be a mining plan before getting the mining lease. So that is violation of the same act and rules, according to them, not my submission, Lord. In my humble submission, everything was done, except there is some minor irregularities in execution of the mining plan, mining lease deed. Then what is the other condition? Clause 5, at any stage, when it can be number 5. At any stage, if it is observed that the information furnished, comma, data incorporated in the document are incorrect or misrepresented facts, the approval of the document shall be revoked with immediate effect. So that is basically in case of any forgery or fraudulent act. So that is not the case here. They have given us 84 number of comments where there was some kind of shortfall or lacuna. We have overcome everything to the competent authority of central government from Dhanbad. Then 6, if the approval conflicts with any other law, here also any other law, if this approval conflicts with this law, then the things would have been different. What they have said, if this act conflicts with any other law or court's order direction under any statute, it shall be revoked immediately. So my humble submission is that
Any other law means other law, not.
other laws, not this law. Because they have acted upon the law which governs their function. Their every action is guided by the rules and the act. Let us see what is there. Chapter 5. Chapter 5. Complaint. Page 78. Chapter 5 of the statute combination. Chapter 5, preparation of the mining plan and system of clarification. Sorry. System of certification. Have lots of copies. 13. Mining plan, no mining operations shall be undertaken except in accordance with the mining plan, which has been approved by any officer of the Indian Bureau of Mines, IBM, duly authorized in writing by the Central Controller, Indian Bureau of Mines, pursuant to clause B of subsection 2 of section 5, in accordance with rules 15, 16, and 17 of these rules. Number B, it is in accordance with the system established by the state government for the preparation, certification, monitoring of the mining plan pursuant to the proviso to clause B of subsection 2 of section 5. So in our case, it is the first which is applicable. The mining plan shall incorporate, the details are given. Then 14, rule 14, this 14 says system to be established by the state government for mining plan. So we are not into this. 15 says preparation of the mining plan. Every mining plan under clause B of subsection 2 of section 5 shall be prepared by a person having the following qualifications and experience. Then coming to, I'm not reading 2, 3, 4 of 15. Now procedure for approval of the mining plan. The mining plan shall be submitted to the officer specified in clause B of subrule 1 of rule 13. Every mining plan submitted for approval under subrule 1 shall be accompanied by such fee as may be prescribed by the Indian Bureau of Mines. The IBM shall dispose of an application for approval of the minings within 90 days, provided that the aforesaid period of 90 days shall be applicable only if the mining plan is complete in all respects, etc. 4. The approval authority of the mining plan may, by an order in writing at any time, direct modification of the mining plan or impose such conditions in the mining plan as it may consider necessary. So all the clauses which are incorporated there in the approval comes under 16(4). So they can impose certain conditions. Any person aggrieved by any order made by direction issued in respect of the mining plan by an officer of the Indian Bureau competent to approve mining
Let us
plans
not
other than
Let us not read 11, 16.5 and 16.6.
Lordship. Then 17.
That is his argument.
On
16.5 and 16.6 is his argument.
we can always come before this honorable court. There is rampant violation of the principle of natural justice. So 17, modification and review of the mining plan. The mining plan, once approved, shall be subject to review and updation at an interval of every 5 years, starting from the date of execution of the duly executed mining lease lid. So that 5 years has not commenced yet. If we have to see the deed from the viewpoint of 7-11. So everything is guided, everything is controlled under the rules lordship regarding the functions and activities of IBM. They cannot go beyond this. There is no trust power given to them.
Can you come to rule 20?
Lordship.
Rule 20.
20. Lapsing of the mining lease. Subject to the conditions of this rule, where mining operations are not commenced within a period of 2 years from the date of execution of the mining lease, or is discontinued for a continuous period of 2 years after commencement of such operation, the mining lease shall.
Now kindly come to 22.
2.
Yes.
The lapsing of a mining lease shall be recorded through an order by the state government and shall also be communicated to the lessee. Where is the state government?
That is your jurisdictional one.
That is a jurisdictional one. Where a lessee is unable to commence the mining operations within a period of 2 years from the date of execution of the mining lease, or discontinuation of mining operations for reasons beyond his control, he may submit an application to the state government explaining the reasons for the same at least 3 months before the expiry of such lease period. Then there's a proviso. There is another situation, lordship, when the state government can revoke the mining lease. That is when, after completion of all the requirements as given under Rule 7, Sub-Rule 10, and if within 90 days we do not do it, lordship, then also the state government can revoke if we are failing to execute the mining deed, lease deed. So there is another situation when the state government is empowered to revoke the mining lease. For that, straightway lordship may come to page 64. Even termination can be done only by the state government.
Can you come to 27?
22, lordship, for a
27.
moment. I am going to 27. Termination also, the state government is empowered.
Kindly come to 27.
27.
This similar to
Order of the state government. Any person claiming to be owner of a land and desiring to grant a prospecting order of the state government. Any person claiming to be owner of a land and desiring to grant a prospecting license or mining lease, as the case may be, with respect to the said land, shall make an application to the state government for authorizing grant of a prospecting license or mining lease, as the case may be. So a individual private person can also, yes, the chapter heading is very clear. When a private person, it has to be his own, he must have title over that land, other than the government landlord. The chapter's heading is procedure for obtaining a prospecting license or mining lease in respect of land in which the mineral based in a person other than the government. And The provision of this chapter shall apply only to the grant of prospecting license and mining license in respect of land in which the mineral vests exclusively in a person other than the government. So this, in my humble submission, Lordship, is totally not applicable in our situation. But if you look at the scheme of the thing, there is another area where the mining lease and the prospecting license can be granted by a private individual also, subject to approval of the state government. But he will have to pay royalty to the other. That happens when the contractors buy some land or gets into an agreement with a private person when the earth is taken for earth filling jobs. Whether the royalty has to be paid to the, but that is a big case, Lordship remembers.
I think some of the minor movement.
The minor, but in that situation also, he is the owner of that land. So whether the forest department or the state has any right to claim any royalty over that land or not. So this termination clause is very clear, Lordship. In the event of termination of mining lease under the provisions of so and so, the state government shall have the right to enforce the performance security to the lessee and carry out the protective reclamation and rehabilitation measures of the area. The lessee shall pay the amounts, etc. So, if we look at the overall scheme also, apart from the functions and operations as given in chapter 5, there is very limited role of the IBM. The IBM can only impose certain conditions in terms of Rule 16, Subrule 4, where they can impose some conditions in the mining plan as it may consider necessary. And their whole exercise in giving the approval of the mining lease, a mining plan, was done in terms of Rule 13, 15, 16. So they cannot go beyond this. And the conditions which they have incorporated in the approval from 1 to 11, and according to them, they are invoking their authority on the basis of clause 1 and clause 6.
They could have taken, as per your submission, they could have very well taken other acts, but not the MMDR Act or the rules frame.
No, they can now, what they are saying, if the approval conflicts with any other law, now there is no other conflict. They are not highlighting any conflict
No,
that we
therefore
are.
your submission, they could take into account other laws, apart from MMDR.
My submission is very clear also, that they can revoke the permit. Because what they are doing, the Impugn Act is, Lordship, they are revoking the approval. So in what situation they can revoke it? If there is violation of the MMDR, at all, if we follow, if this approval conflicts with any other law, so any other law will not include the MMDR Act and the MMDR rules. And number 2, they can also revoke it if they can find that there are some documents, wrong information was given, or there was a misrepresentation. These are the 2 areas where they can revoke it. For other purpose, they can always modify it. That is also after execution of the mining lease date. Thereafter, after 5 years, when the actual mining operation starts. Because from the situation, if the mining starts, the situation will definitely change in that topography or in that terrain. So they may definitely look into the mining plan after expiry of 5 years from the date of operation of the mining activities. In my humble submission, they are beyond their authority to even passing a comment how the lease deed was executed. That role also they cannot adopt. Their whole area of activities is relating to the mining approval of the mining plan. They cannot go beyond other activities, whether the state government has rightly done it, wrongly done it. They are not the monitoring authority of the state. They are the monitoring authority of my mining plan only. That is the role given to them, and they are circumscribed by certain procedures, and which they have done. I have elaborately explained those and placed those also. Their authority came for inspection. They found 84 number of shortfalls. They gave the comments. We have to rectify those, and after rectification, they did another inspection and found everything is in order. And thereafter, they issued the approval. Now, if Lordship is free to take my submission. So, number 2, point of IBM circumscribed by Chapter 5 MCR. The impugn order has been issued exercising the power delegated by the Gazette notification dated 18/5/2016. So I have already placed that the earlier date, Lordship. It only says their action has to be governed by Rule 16 and 17, not beyond that. So which I have, and Lordship has just made it. This notification in turn has been issued in exercise of power under Section 5(2)(b) of the MMDR Act, and the authority of IBM has been traced to Rule 16 and 17 of MCR 2016. Thus, the source of statutory power to issue the impugn order is undoubtedly relatable to Section 5(2)(b), while the authority of IBM was with respect to mining plan is considerably circumscribed by Rules 16 and 17. Last paragraph of the impugn order notification has been referred. They have very categorically mentioned it. Regarding the revocation power, Lordship, there is no provision in the MMDR Act or MCR 2016 that contemplates revocation of an approved mining plan. Rule 17 authorizes IBM to review and update the mining plan, but only after a period of 5 years. A power of periodic review cannot be considered a power to revoke. Lack of jurisdiction of IBM stands concluded in the, I have already placed it, that JKCM Central Limited versus Union of India's case, where the Madhya Pradesh High Court very categorically held that IBM does not have the power to revoke a mining plan, and Section 21 of the General Clauses Act would not be resorted. IBM has conceded to this position in paragraph 9 of the judgment. Most importantly, the IBM has accepted this decision, having not challenged it before the Honorable Supreme Court. This is a quite old judgment, Lordship. Till now, it is in force, and there is no challenge to it. And IBM's stand regarding lack of jurisdiction IBM to the revocation has already attained finality. And the most important and pertinent point which I would like to highlight is that the Madhya Pradesh High Court's division bench judgment is related to the provisions of Section 5(2)(b).
Now, Secretary, tell me,
Lordship.
if there is a apparent illegality,
Apparent illegality.
is it a submission that IBM has to close its eyes?
Number 1, Lordship. Mining plan itself is not sufficient to grant mining lease, as well as allow the state government to go for the allow me to go for the operation, that is the mining operation. Mining plan is just a license, and which fulfills one of the requirements for the state government to give me the mining lease. That is one of the requirements for the state government to follow the dictate of 711 to execute the mining lease deed. Mining deed itself is not sufficient for any authorities or any persons or any company to start. I am having a mining plan approved by them. What will that serve? There is absolutely no illegality in the mining plan. Where is the fault? My submission is that IBM has their jurisdiction of the mining plan. Where is the flaw in the mining plan? Their whole concession thing is that the mining lease deed was not done as per the procedure laid down. For that, how mining plan is affected? For that, the mining lease would be affected. That is just my submission, not my, or execution of the mining lease deed. For that, it can be a problem. But mining plan itself is not flawed. Certain things, that is why my submission is that if the state government had revoked the mining lease or did not allow me to proceed to execute the mining lease deed, things is in the domain of the state government. For that, the mining plan will not get initiated. The mining of the IBM's authority is that whether that area has proper mines and ores, whether it will be extracted as per the requirements of the technicalities, those areas they can see. When they have indicated 84 number of comments, let us see that. Whether that included what procedure the state government have to follow regarding issuance of mining plan or mining lease or the execution.
That
Those
I've-
areas are not within their domain.
Mr. Saike, I've understood that aspect. You know, requirement for that.
If the state has
only
interfered,
asking
then
you.
things would have been different.
So therefore, your submission is whether the mining, the entire proceedings have lapsed or not. It is for the state government to look into,
Yes,
not,
because
not for the IBM to.
if IBM cannot give me a mining lease, they do not have the authority to give me. To get that mining lease, whether before or after, that is a different area of my argument. I must have a mining plan. So suppose let us take the example of a liquor approval. The government has given me the liquor license. But for that, I must have a trade license. The excise department will not control the trade license. It is the domain of the Guwahati Municipal Corporation. Whether the building fulfills all the requirements regarding the place where I am going to stock the liquor bottles and sell. That is under the domain of GMDA, various authorities. But suppose I get the excise license. Excise license itself will not allow me to start the operations of selling liquor on or off. I must fulfill the other conditions. And excise department cannot pass a comment whether GMDA or GMC has rightly issued the building permission or whether the GMC has rightly or wrongly issued the trade license. That is not their domain.
Or the example would be much better
Yes, Lordship.
as to
That's why we
Can-
always wanted Lordship in this side.
can GMDA or GMC at the time of consideration of the trade license consider that the excise license was wrongly given.
No, that is not the domain of GMC.
That is what I'm saying.
That is not the domain of GMC. Now, the state government cannot pass a comment
No, no,
whether approval was rightly
No.
given or not by IBM.
no, Mr. Sagar. Your argument that the GMC who is issuing the trade license cannot question the excise license given by the excise department.
Yes, Lord.
In your submission.
That is my
And
subject.
therefore,
Everybody has their own domain of operation.
IBM cannot question the question of how the mining lease was done. It is only
Absolutely.
limited
How the
to
lease deed
mining
was
plan.
executed. That is
Yes,
not in their territory. They can act. Suppose regarding these 84 points or other requirements to get a mining plan, if the mining plan is in order or not, that is their area where they have to exert their expertise. Their role is very limited regarding the validity, number one, genuinity, and the other fulfillment requirements, which are to be fulfilled.
And what is the role of the central government?
Central government. Yes. In the written documents, they have stated the grant of lease and execution of lease deed falls solely with the jurisdiction of state government. And the Indian Bureau of Mining has no jurisdiction to invalidate either of them. What more is required, Lord? This cleanses my case. If Lordship accepts this.
So that is what I failed to ask you. I asked.
Written submissions they have given this special paragraph. Lordship, you can kindly take it. Page 4. So if this is the case, which I am arguing for last 3 days on the point of jurisdiction. If this is the case and if this is a written submission, on what basis they have issued the impugned order? If the state government revoke the mining lease or do not agree for execution of the mining lease,
or for that affair.
we'll have a different case.
So therefore, I refer to 22, the rule. It is the state government who has to decide on the question of lapsing of the.
Exactly, Lords. And that has to be done by an order and everything has to be in black and white. Writing. And before that also, I'll get an opportunity, everything, lot of other things will apply. But the gentleman sitting in IBM, he cannot be an expert on this area. In my humble submission, he has outreached his jurisdiction. He has overstepped. He crossed his boundary. So that is not permissible and that is in violation of the statutory rules and provisions and the overall scheme of things. In fact, I don't have to go further. On this point also, Lordship, the impugned order is bad and liable to be set aside. But I will go to the other points as an abundant caution. If Lordship decides that the jurisdiction point only, then this is my submission. Lordship will kindly come to my point number 5. IBM cannot opine pronounced on validity of grant of mining lease. The grant of the mining lease is done by the state government under Section 5 of the MMDR and in terms of Rule 7 of the MCR rules without reference to central government IBM. IBM does not have any authority over the process of granting the mining lease and therefore cannot comment or interpret the validity of the grant of the mining lease. No competent authority has held that the petitioner's mining lease is void in terms of Section 19 of the MMDR. So let us pause here for a while. What is Section 19? Section 19 very clearly says it is regarding, just 1 second. Prospecting license and mining lease to be void if in contradiction of the act. So here also mining plan is not included. Section 19. Only 2 areas where it can be implemented. That is in case of prospecting license and mining lease, not mining plan. Section 19 of the MMDR. So in that view of the matter, Lordship, while the state government issues the mining lease or executes a mining deed lease, mining lease deed, there is no requirement of any consultation with IBM. There is no requirement of getting any approval from IBM. There is no reference to IBM when the state government issues the mining lease or grants the mining lease or goes ahead and executes the mining lease deed. So state government also don't have to consult the party which applies and who for a mining lease, they will have to obtain the approval. And for that, the state government has no business to communicate with the IBM authorities unless they doubt about any fraudulent acts to verify. Leading further, even if an order is void, it is first required to be set aside by a competent court of law and cannot be declared so in a collateral proceedings in the absence of authorities who are the authors thereof. So I'd like to place this judgment, Meenakshi versus Metadin, 2006, 7 SCC, page 470, paragraph 18. It is a well-settled principle of law that even a void order is required to be set aside by the competent court of law, in as much as an order may be void in respect of one person, but may be valid in respect of another. A void order is necessarily not non-est. An order cannot be declared to be void in a collateral proceedings, and that too in the absence of the authorities who were the authors thereof. The orders passed by the authorities were not found to be wholly without jurisdiction. They were not thus nullities. Let us see. If anything is wrong, it is the state governments and they can do it through a proper proceedings. So IBM has no role. IBM may advise the state government, but that is not in our domain. They may indicate.
I have understood on the position of jurisdiction, and the second point is more particularly is the most crucial point is it a mining lease?
It is a mining lease. Lord.
You say that it is a mining lease.
Lord.
If it is a mining lease, would that mining lease have been granted without a mining lease?
Yes.
How? That's the question.
We have to read Act Section 5 with Rule 7.
Let us read Section 5.
Let us, yes. Straightway, Lordship, I'm coming to the next point.
Let us not, Mr. I'll read this. Coming to your point, tell me how it is.
Yes, how we have elaborated, Lordship, I can straightway get.
No, let us make the arguments to that. How do you say it about 5.2? Because he has argued on that.
5.2.
How you
5.2 earlier it was
categorically said no mining lease shall be granted.
The Act of 1957, prior to amendment in 2015, there was a requirement of fulfillment of two conditions. There is a word and. Lordship will kindly take the compilation. It 15. Text section 15. Here, I am on 5.2. No mining lease shall be granted by the state government unless it is satisfied. Number 1, A. There is evidence to show that existence of mining contents in the area.
Come to B.
Now, I'll go to B. A is important because I come under A.
Where is the or?
There is no or, but earlier it was, Lordship will kindly come to the footnote 34. Earlier it was, there is a and. Lordship may kindly mark that. That and has been deleted. This is where my learned friend NNB Chaudhary missed out. As they were not arguing, so we did not have to put it. Now Lordship has putting this question, so we will clarify it. That word and was earlier there, now it is not there. In 2015, 12/1/2015, so I got the mining lease in 2021.
So you mean to say
that and is no more.
As the word and is not there, you are to read it as or.
And now let me place, Lordship, including the proviso. There is evidence to show that existence of mining content in the area for which the application for a mining lease has been made in accordance with such parameters as may be prescribed for this purpose by the central government. So we got this prospecting license, so we have done it. And B says, there is a mining plan duly approved by central government or by state government in respect of such category of mines as may be specified by the central government for the development of mining position there. So those who are having an approved mining plan, they come under B. Now, proviso. Provided that a mining lease may be granted upon filing of a mining plan in accordance with a system established by the state government for preparation, certification, monitoring of such plan with the approval of the central government. Now coming to my the appeal, the ground. We submitted a mining plan.
Where?
Down to page 16.
Oh, this.
B. For that, the compliance of the requirement of 5.2A is uncontested.
So reading
Page 16 of my read petition. page 16B. For that, the compliance of the requirement of section 52A is uncontested, and in compliance with the provisions of 52B has also been done by a communication dated 25/1/2021 prior to execution of the mining lease, whereby the petitioner number 1 had filed a copy of the mining plan with the state government.
No, no, there is a mining plan duly approved by the central government.
No, it has not to be central government. Lord,
Yes.
say.
Kindly see.
Proviso can kindly come.
The mining plan.
Provided a mining lease may be granted upon filing of a mining plan. That is not an approved mining plan
In accordance with the system established
by the state
for
government.
preparation
So
for the
that is why we gave it to the state government and
with the
state government
approval
issued
of the central government. With the approval of the central government.
that approval, lordship, the central government and the state government is between them. But our requirement is that when we applied under 52A, and we have to read with the rules now. I'll go to the rules immediately. I'll go to the rules straight away. Now, 52A and the proviso very clearly says that if there is existence of mining contents in an area that we have on the basis of our prospecting license we have submitted, and also submitted a mining lease, mining plan with the state government, and state government acted upon it. Therefore, we are saying this: if state government indicates something wrong, then we'll have to give them reply. But they have till now has not done anything to the contrary of our interest. Now, let us read this 52AB along with rule 7. 7, lordship, page 63. Here we come under 7 because there are two things. 7 and 8. In case of 8, lordship, it is letter of intent. So we fall into the category of prospecting license holder. So we come under 7. So 7 says right of a holder of a prospecting license to obtain mining lease. On the very top, it is written, lordship. Heading is very clear. Right of a holder of a prospecting license to obtain a mining lease. So which I fall. The holder of a prospecting license granted prior to January 12, 2015. That means we fall. Or pursuant to Rule 5 may, upon fulfillment of the conditions specified in subclause 1 to subclause 4 of clause B of subsection 2 of section 10A. Pausing here for a moment. Let us go to 10A now. Section 10A. Lordship will kindly come to page 23. Right of a existing concession holder. So prospecting license holder comes under this category of concession holder and applicant. All applications received prior to the date of commencement of the MMDR Act Amendment 2015 shall become ineligible. We do not fall into that. We come to the next. Without prejudice to subsection 1, the following shall remain eligible, and from the date of commencement of the MMDR Act 2015, A, applications received under section 11A, that is relating to coal, so we are not under that. B, where before the commencement of the MMDR Act Amendment Act 2015, a reconnaissance permit or prospecting license has been granted in respect of any land or for any mineral, the permit holder or the licensee shall have a right for obtaining a prospecting license, followed by a mining lease or a mining lease as the case may be in respect of that mineral in that land, if the state government is satisfied that the permit holder or the licensee as the case may be. Pausing here for a moment, we fall into the holder of the permit or the prospecting license has been granted with respect of the state mineral. So we fall in one category.
Maybe number, no, you follow into every.
Now, 1, 2, 3, 4, let me place it.
No, you come under 1 to 54. There's no quarrel with that.
No quarrel. So what rule 7 says, those who fulfills the conditions under 10A So we have to read 7.1 with 10A. So we fall into that category. Let us proceed further. Okay. Makes an application to the state governments for granting of a mining lease. So our application is for mining lease. In the format specified in Schedule 6 within a period of 3 months after expiry of the prospecting license, which was expired in May 2019, and by August 16 or 17, within 3 months, we applied in Schedule 6, or within such further period not exceeding 6 months as may be extended by the state government. 2. The state government shall send an acknowledgement of receipt of the application submitted under Sub-Rule 1 to the applicant in Schedule 2 within a period of 3 days on receipt of the application. We have submitted these formalities fulfilled, provided that the holder of the prospective license who has made an application within the time limit specified in subclause 4 of clause B of subsection 2 of 10A to the state government for granting of a mining lease. All these applications are mining lease. Lordship,
76 of you.
76. Base
76.
76.
Yes.
Yes.
76.
The state government shall, on being satisfied.
Of your repetition.
Is yes.
This is
25
the
on
mining
2000.
plan you submitted
Yes.
prior to the mining, as per you, the mining lease being granted. This is 25/1/2020.
Lordship.
To come within the proviso to the section 5(2). The money.
No, we
Yes.
do not come under 5.2. We still come under 5.1, 5A.
You submitted this, kindly see pen HFT.
Yes, that is why we have submitted it.
That is why I'm
We
saying.
submitted, but
But
it
where
was not
is
approved
the
at that point of time.
But where is the approval of the central government to submit this?
That the
Without the approval of the central government, how can this have any relevance?
the system.
It was-
Let us go to the proviso once more.
Yes, in this compilation, that proviso is not that the
No, no.
deadly proviso which has made the entire case. Why did you not hear?
One.
You have given the amended act, no?
Yes, we'll go to that, Lordship. Just 1 second. Here, 5.2 proviso, page 15. Provided that a mining lease may be granted upon the filing of a mining plan in accordance with a system established by the state government for preparation. So that system,
For preparation, certification, and India, with the approval of the central government. Where is the-
so that, Lordship, that is not our area.
But then also, the state government could not have done it unless there is an approval. That is the question.
The system has to be approved by the central government. The system,
No.
Lordship will kindly see. Let us read it slowly.
This needs an interpretation by the division bench after this court. With the approval of the central government.
And if Lordship decides on jurisdiction, we don't have to go through all these complications. But I love these complications, Lordship. I'm enjoying it. So,
Now, why do you say now we are to read or in between A and B? Why do you say? In fact,
earlier, it was and deliberately the central government, his wisdom, has withdrawn it, deleted it, or omitted it. Because there is an amendment in the rules. The rule says the mining lease will be granted, can be granted by fulfillment of certain conditions. Those conditions do not include the conditions that I have to submit a approved mining plan at the time of obtaining a mining plan, mining lease.
But because of the all parent taken done. This code makes it very clear. Don't have an inflation later on, and the code will make it clear. Section 7, Rule 768 only states about an order, which is different from the earlier Rule 22.
That may be lordship, that is lordship domain, whatever opinion lordship gives, but my submission on the basis of all the judgments is very clear. That order is a order of grant of mining lease. That same word is finding place in other parts of the rules also. The same order.
So here there is nothing mentioned. There is order of granting.
Suppose lordship, let us assume, whatever is falling from, let us assume that is the correct. Then where is the provision the other side will show that a proper order of grant of mining lease has to be issued under the rules and the statute? That is not there.
That is what was not done.
No, that is done. That is done not only by Arunachal government, that has been issued, that same kind of order is issued by Karnataka government also. Around the country, the same order is issued.
Karnataka government at that point of time they did it because the Karnataka government
My
did at the time
submission is
prior
that
to
there
the
is a
2021
specific format for the
amendment.
lease, but there is not a specific format under the rules as well as the statute regarding the grant of mining lease.
In fact, the issue, yesterday I was taking up another matter of Mr. K. N. Chaudhary. So the question involved therein was that there was a direction to deposit 15% of the amount after the issuance of the provisional letter of intent as per the mining, Assam Mines and Mineral Rules. But the fact is, neither the tender said nor the Assam Minor Mineral Rules say that there is any concept of a provisional license, provisional letter of intent. Only thing which is being given is a letter of intent. It seems that the governments are still functioning with the mode keeping prior to 2015, but without taking into account that what has happened subsequently.
Lordship, here, if we harmoniously read the provisions of section 5 with the rule 7, it will make abundantly
Mr.
clear.
Sakya, show me a judgment to the affair that if there is nothing mentioned, one has to read it or in between 5A and B. That is your clean sheet, a clean sheet.
In our case, I will face, no doubt.
That is the issue.
Now, Lordship will kindly come to now, at what point that there are two events contemplated in Rule 7, two major events, which are different. The first event ends at 7.6. That is the grant of mining lease. The second event is at 7.11. Execution of the mining lease deed. These are the two events. After 7.6, the state government have no role to issue any order to us, which has been accepted by the Karnataka High Court also. After issuance of the mining lease order or grant order, Lordship, the state government role is over, except they will be a part of the execution of the mining lease deed. There is no order they have to issue. No approval also is not required from them. They can only revoke the mining lease from between 7.6 and 7.11. Let us go once more, Lord. 7.6 and 7.11. In 7.11, the state government is empowered to revoke the mining lease. grant of mining lease. If I have a mining lease, then only they can revoke. So in between 7 and 11, where is any provision that empowers the state government or that requires or that mandates the state of Arunachal to issue another order? Let us come to 7.6, Lord, for my satisfaction, Lord. So in 7.6 says, communicate through an order its decision to grant. What is that decision to grant? Communicate through a order and its decision to grant. That means their decision is to grant license and they have to issue an order. Else they would have to say that
Kindly see, no. See, 7.6 says about an order. Doesn't
Order.
say about a mining lease.
yes.
See 7.11. It also says about
Let us come to 7.10. 7.10
no,
also
7.10,
mentions
Mr.
There's the order
Miss,
in
no,
7.10
Mr.
also.
Saikia, 7.10, I've read it. I'm saying about 7.11.
Yes.
Kindly come to 7.11. It says that the state government may
Shall
revoke
execute.
the order granting the lease. It doesn't say the revoke the mining lease. It says revoke the order of granting the lease.
That is what Lordship. In between, where is the scope from 7 to 7.10? There is another requirement of the state government to issue another order. Let us see from the other perspective. What they are saying,
Therefore, the proviso was brought in that if you don't have a mining lease, in spite of an order, nothing remains.
while now Lordship will kindly come to 10. That if that can be Lordship's view, I do not cannot argue against
Because
that at this
it
stage.
never
but my
says that
submission is very
upon issuance of a mining lease. It says upon issuance of an order. Kindly see,
That is the
7.10.
10. What does this say? 10. Upon issuance of an order under clause A of rule 6. Then Lordship will not read or sub rule 9. For grant of a mining lease.
Yes.
So what does it say? Upon issuance of an order under clause A of rule 6 for grant of a mining lease. So now, if we read this along with 7.6, that order is for grant of a mining lease. There is not a decision of a mining lease.
There is no quarrel with that.
That-
I am in agreement with you. But whether an order to grant a mining lease would amount to a mining lease, that is the question.
Grant of
There's a
Yes.
difference out there. Tomorrow,
Only-
are you going to say, no, we'll
No. We have to read it with 10A now. While I have received a grant of mining lease, whether immediately I can start the operations or not.
an order of grant of
Order of grant. Yes. Let us come to 10A now. Obtain all consents, approval, permit, no objection as may be required applicable under applicable laws for commencement of the mining operations. So the order for grant of mining lease has been given, but I cannot start operation until I get all these consents, approval, etc. This approval also includes approval of the mining plan. Coming to then deposit of the performance security B. C. Satisfy all the conditions with respect to the mining plan specified in clause B of subsection 2 of section 5. So I have to
So now you have to comply 5.2b.
5 to B.
You have to comply then.
So that is why 10A says, what is 10A? That approved mining plan.
So therefore, you are to comply with 5.2b after the order of grant of a mining lease.
After
Then if this is so, how do you harmoniously read with section 5.2b
that
where
is why
5.2 which categorically
10
mentions?
starts. That is sub rule 10 says upon. Upon is the starting word. That means upon issuance of an order under clause A of sub rule 6. That means after the order of grant of lease has been issued, I have to obtain all consents, approval, etc.
Including the mining plan in terms with 5(2)(b).
5(2)(b) is the power given to IBM,
No. Power is given to the IBM in some other provision.
other
Which is-
code, but
But here you are to satisfy therefore to
that is what
5(2)(b).
I am submitting, Lordship. That 5(2)(b) speaks about obtaining a mining plan with approval. That is the thing. So that we have to obtain after grant of mining lease, not before. That is why upon it,
Then are you saying, then why section 5(2)(b), 5(2) categorically said that
that
two
is
mining
why
lease
that
shall
and has
proceed?
been removed. That is why the and has been removed. And there is an amendment of 2015, read with 2016 new rules of concession.
Just like here, if it is a question of only jurisdiction, you have a fair chance, otherwise bad. Okay, hearing complete, judgment reserved.
My written arguments, Lordship.
In fact, the only help you are getting is from the central government.
Lord.
The only help you are getting is from the central. And with their written argument. They become balcony. And appears on behalf of the petitioner for this.
My lord, Mr. Asbot is on his way.
2 weeks.
For admission, item 8.
Yes, Mr. Ali, what is your case?
Very pleased, Lord. Lordship, I am the owner of a plot of land, Your Lordship. And that plot of land, Your Lordship, is situated in the revenue village, Amintong, Your Lordship. And out of that is the 2 visa 1/12%, that is the area of the plot. And I purchased this from the recorded purchasers and possessorship law. And out of that, Your Lordship, the state government has acquired land measuring 2/18 lesson. Out of 2 visa 1/12%, that is remaining 2 visa that has not been acquired, only 1 visa 2/18 lesson has been acquired for constructing a road here to connect the newly constructed Brahmaputra bridge in the connected Guwahati and the North Line. And for that, Your Lordship, they have started a land acquisition proceeding, that is 18 of 18. Land acquisition and proceeding, Your Lordship, that is 18 of 18.
The what provision?
Under the 1964 Revocation Act, Your Lordship. But so far compensation is concerned, Your Lordship, as per the notice, it is given under the new act, that is 2030. So I have been asked by Annexure to Your Lordship that you hand over the position And also you take the compensation for this GRED. That is amounting to 7 lakh something year. And so for the compensation for the land is concerned, your lordship, for that also I was asked to take it, your lordship, receive it, your lordship, by providing indemnity book, addressing other particulars and documents. I have furnished everything, your lordship. So when it is about to disbursed by the land acquisition officer, the respondent number 5, your lordship, that is a private respondent. Respondent number 4, your lordship, a private respondent, made a complaint before the land acquisition officer that this is my land, there is a proceeding pending before the High Court. So the amount should not be disbursed. Now your lordship will find under the Land Acquisition Act, your lordship, that man is neither a person interested, he is neither a landowner, your lordship, and he is no way connected with the land which has been acquired, your lordship, that is 2 kota 18 lakhs. He is no way connected. His case is, your lordship, he filed a suit, your lordship, against my vendors in the year 2008, that is 148 of 2008. And in that suit, your lordship, he got a ex parte decree. And that decree was for specific performance of contract, and he made some payment also to vendors. Those vendors, your lordship, after having received advance, did not execute the sale deed, nor took any steps, your lordship, for obtaining permission. Anyway, your lordship, when the decree was passed, your lordship, in that case, your lordship, now your lordship will come. In that decree, your lordship, there was a time period given. That is, your lordship, I am coming. At page, your lordship, 55.
Yes.
At page 55, your lordship, the order person is like this. In the result, the suit is decreed ex parte with cost for excessive performance of contract, directing the defendants to execute and register the sale deed in favor of the plaintiff by accepting the balance consideration money within 6 months from today. Plaintiff means, your lordship, the present respondent number 4. The defendants are also restrained from selling the suit land to any third party. Now that 6 months period, your lordship, elapsed, your lordship, long back, that is on your lordship, February 2000, February 28 February 2009, your lordship. 6 months elapsed, your lordship. He neither paid the balance amount, your lordship, to the judgment debtors, nor he filed any execution proceeding before the trial court, your lordship, to get the sale deed executed to the court. Now, since then, your lordship, it is 2024, your lordship, for last about 14 years, your lordship, he has not filed any execution proceeding, nor he has paid. That being a conditional decree, your lordship, as I have read out, your lordship, that conditional decree, your lordship, he did not fulfill, your lordship, and he did not pay the amount to the judgment debtors. Beyond that, your lordship, that land was sold by the vendors, your lordship, after 19 months, your lordship, as it appears from the record, your lordship, on 7/12/2009. So on 7/12/2009,
Sir Ali, why should this court look into all these things? Why you are not making a reference?
lordship,
Why you are not filing a reference?
filing, your lordship,
A reference. It is a reference court who can look into this.
Your lordship, here it is, this is not the, it is not within the purview of the reference court.
Why?
Because to whom it will be paid, your lordship,
That is the question of
It is-
apportionment as
point
regards
is clear,
entitlement.
position is clear, your lordship. Position is clear, your lordship. I am the
Absolutely no.
landholder.
This court is not going to touch all these things. Whoa, you put a
I am
reference.
recorded partner, I am the
So
owner
what?
of the land as on.
All these things are to be decided by those courts. This is not for a writ court to look into this. Whether who is entitled or who is not entitled, this is not going to go ahead. Whether he has a decree to that effect, how far is the decree executable, whether it is not, this is not for the court to look into it. Go there, file an application on the 12th before
So for the,
before the land acquisition officer.
so for the land acquisition is concerned, your lordship, that does not come within that part. Now it is, your lordship, section 64.
Why are you going into 64? You go on the 12th of the Land Acquisition and Requisition Act. Go there.
Now, your lordship, so far this 64 is concerned, your lordship, refers to authority. Refers to authority, your lordship, that is,
First of all, 64 is only for the purpose of granting you the compensation as regards the compensation in terms with section 26 to 30 of that act. But however, by way of the legislation by incorporation, the provisions of the Land Acquisition Act 1894 have been taken. So the provisions of section 18 of that act would apply, of the 1894 act would apply.
suppose that 18 applies, your lordship, so that also does not cover your lordship.
Has the amount been released? No, I'm not on that. I'm asking you, has any amount been released to you? So the government has to apply let the collector, whoever it is, he ask him to deposit it in terms with section 30 of the Land Acquisition Act 1894, because the state provision has also been incorporated in the 64 Act. So that has to be kept out there in the court, and the matter, you refer it to the, what you call, the reference court. You know how you do it. It's not the court.
Lordship,
Yes. Again, why you are coming into the question of suit? Whether you are entitled or he is entitled is not for the court to look into. Why should this court look into it? I'm not concerned with all those aspects. As to whether he is entitled or you are entitled is a different thing, because kindly see, the provision, all other aspects are not entitled. Let the reference court decide. The reference court is the district judge. He will be best off to know what is to be done.
now your lordship, so for the compensation for Zirat is concerned, your lordship, it has been paid to me. That I am the owner of the land, I am the.
Again, if he has got the money, you are to file a reference. If there is a dispute out there, the collector should not have deposited, paid the money. Only see section 30 of the Act of 1894. You have the old book, new book. Why you coming to the new Act? 64 Act only by legislation, by incorporation, only incorporates
So
the
it is-
1894 Act.
Regarding dispute as to apportionment. So there is no question of apportionment, your lordship, because I.
Kindly see the Mr. Ali, kindly read the entire section properly. As regards entitlement also.
When the amount of compensation has been settled under section 11, if any dispute arises as to the apportionment, of the same or any part thereof or as to the persons to whom the same or any part thereof is payable.
That is the thing.
The collector may refer such dispute to the decisions of the court.
Who is entitled to, the collector cannot decide.
So under
It is for the collector to refer to make a reference to the reference court. Anybody receiving an amount can very well receive under 31(2), under protest.
here also under Article 226, because it is my property, your lordship, after, because I am from all corners, your lordship, they can't dispute my ownership. I am recorded, I have been indicated.
Mr. Ali, you are a civil court lawyer. Are you going to tomorrow say in the civil court out there, when a suit is being filed, that he cannot object, unless such forget about the suit, kindly pass the decree on the first day without any evidence? These are questions of evidence which needs to be looked into by the reference court. Whatever may be, Mr. Pupon, dear Mr. Pupon, I'm not concerned with all these things. I'm not going to listen to all these things. These are matters which should not at all be, first thing, notice has not, shouldn't have been. Heard Mr. S. Ali, the learned counsel, appearing on behalf of the petitioner. Mr. S. Burwa appearing on behalf of the district administration. And the S. Burwa appearing on behalf of the district administration. Mr. A. Bachcharji appearing on behalf of the revenue department. And Mr. A. Pukon appearing on behalf of the private respondent. The dispute in the instant case pertains to who would be entitled for the compensation in terms with that who would be entitled to the compensation in respect to a plot of land at measuring 2 kata 18 lechas covered by Dak number 334 of Firaj Bihari Miyadi Patta number 56 of village Goripur under Moja Sila Sinduri Gopa in the district of Kamrup, Assam, which is the subject matter of an acquisition under the provisions of acquisition being LA case number 18/2018, initiated under the provisions of the Assam Requisition and Acquisition Act 1964. The case of the petitioner herein is that the petitioner is the owner of the said plot of land, and as such, the petitioner is entitled to the said amount. It is further stated by the petitioner that the petitioner have already received the GDAT compensation. However, the compensation in respect to the land in question have not been paid to the petitioner. Per contra, Mr. A. Pukon, the learned counsel appearing on behalf of the private respondent, submitted that he is the owner of the plot of land, and as such, he is the rightful. He is as such, the private respondent is entitled to the compensation. Mr. A. Pukon further submits that the GDAT compensation which have been paid to the petitioner could not have been paid, as the petitioner had placed certain documents which were fraudulently misrepresented. Had submitted certain documents which thereby misrepresenting before the competent authority, before the collector. From a perusal of the above, from a perusal of the materials and report, as well as the hearing the learned counsels appearing on behalf of the parties, the question therefore arises as to whether the petitioner is entitled to the compensation in respect to the land in question, or Mr. A or the private respondent, who's taking into account that the provisions, taking into account that in terms with Section 12 of the Assam Acquisition and Assam Requisition and Acquisition Act 1964, for short, the Act of 1964, permits that if a person is aggrieved as regards if the person if there is a disagreement with regard to the to whom the compensation is payable. Section 11(4). The person entitled to the compensation requiring the person entitled to the very well. File an application before the collector, taking a reference to the court. And it is incumbent, and it is and the state's vision also obligates the collector to make the reference. It is further seen that in terms of section 12, section 2, subsection 2 of section 12, the provisions of the Land Acquisition Act 1894 have been legislatively incorporated, meaning thereby the provisions of section 30 of the Land Acquisition Act 1894 would also be made applicable under such circumstances. In that view of the matter, if this court peruses the provisions of section 30 of the Land Acquisition Act 1894,
But it is equivalent to 76 of the new act. Because
Mr. How can I bring in the new act? I can't bring in the new act.
compensation has been actually fixed under the new act.
Mr. Ali, kindly appreciate. Section 26 to 30 and Schedule 1 of the new act can only be applicable in view of section 24(2) and 106 of the new act. But the fact as regards the other provisions of the act has been already legislated here. So under such circumstances, the provisions of the 1894 Act will apply. The law is clear. If you want, you see the judgment of the Supreme Court in Bangalore Development Authority, wherein it categorically mentions how it is to be done. Anyway, let me continue. A perusal of section 30 of the Act of 1894 categorically shows that if there is a disagreement as regards the apportionment of the compensation or as regards who is entitled to, it is also the duty of the collector to make a reference to the make a reference to the court and further deposit the said amount in terms with section 31 before the reference court. Taking into account the above provisions of law and the facts in the instant case, this court is not inclined to entertain the instant petition on the question of availability of the alternative and efficacious remedy under the Act of 1964, read with the Act of 1894. Be that as it may, this court grants the liberty to both the petitioner as well as the private respondent to file applications before the collector seeking a reference as regards their entitlement to the compensation which have been determined by the collector in respect to the land referred to here in above in LA case number 18 of 2018. It is further observed and directed that the collector, upon such application being filed, shall refer the matter to the reference court for an adjudication. Also, it is further directed that till such that also, this court further grants it is further directed that till such applications are filed as per the liberty herein above granted, the collectors shall not disburse any amount in respect to LA case number 18 of 2018 pertaining to the land in question. However, upon the reference application being filed, the collector shall deposit the said amount before the reference court in terms of section 31(2) of the Act of 1894. It is, however, made clear. No, it is, however, observed and clarified that the directions to the collector as well as the petitioners to act in terms with the provisions of the Act of 1894, to act in terms with the Act of 1864, read with the Act of 1894, should not, however, be construed that the petitioners or the respondents' determination of compensation would be in terms with the Act of 1894. Because it is the compensation which have been determined has to be in terms with the provisions of the Act of 2013.
Orders, item 9.
Yes. Oh, you missed the bus. Can't help it.
Only pay that means it was 31st pay.
Okay. We'll fix it on 3rd of December. 3rd of December. I am not here, so better off let it be done by some other judge. I am not here from 2nd onwards till 16th. 13th I am not here. 16th. Let it be on 3rd of December. Huh?
Wrong, my lord.
3rd of December. We are in the month of November. The marriage petition was filed when? Huh? So, today is what? 12. So another 2 weeks. Missed the bus. I can't help it now. If there was anybody present when the matter is called, then also. Dismiss for default. Okay, 3rd of December. None appears on behalf. Yes, what is this? Mr. B. Gogoi, the Learned Council responded that proposal for payment of land acquisition compensation has been sent by the chief engineer and processed. These are contempt matters. Oh, you have not paid. Land has been taken. Okay, return the land. Return the land. Why do you want it? When the court has passed an order, that's to division bench. Division bench, na?
Then to the division bench.
Principal amount shall be paid by the union particularly as the appellant with interest rate as per section 18 without any further delay. So, this order was passed in the year 2023. We are in the year 2024. You are not releasing it, then where is the question of sanction? No, where is the question of sanction? I don't understand. Sanction or anything that doesn't arise at all. Return the land. You have done for what? Road. Huh?
Roadman.
Road. Okay, where? PWD.
PWD rural.
This matter on 14/11/2024, on which date Mr. B. Gogoi shall apprise this court as to whether the Learned Standing Council for the PWD shall apprise this court as to whether the petitioners have been disbursed the amount. Full stop. If the amount has not been disbursed, Mr. B. Gogoi, the learned, Mr. B. Gogoi shall obtain the head of account of the PWD Roads Division of the Government of Assam. Be attached.
You cannot have a order, so that I can immediately take the order.
Not you, take a photocopy. Say to my device too.
Yes, sir. It's uploaded, I will.
Get the head of that. You attach that, then things will.
Item 10 to 12.
Or any other property that you have. Huh? Things will move then only. Because the courts pass an order, nothing happens.
Against the order dated 21.
Yes, complied or not?
Not complied on under two occasions, assurance was given that payment will be made. A specific
Status in
clarification from
connection
the
with
court,
connection with case insurance or the payment of an amount of remand to the victims beneficiaries under the slippage. This is central government payment.
Lordship, that is,
Financial sanction has been granted.
And-
Then
Just last part for sealing proposal, this second
what's
one.
the proposal? These can't happen like that. These are contempt matters.
Hamarat, paragraph 1 week of your lordship order.
Kindly be approved.
Huh?
Page 10.
We have it on Monday. Get it released. Goodness.
Page 10 of your lordship order, my lord. That's the- Dated at 17.
2 months.
My lord.
2 months. That was passed on 21/7. Monday, release it or bring the head of the account, we attach it. Monday, release it or bring the head of the account, we'll attach it. Get either. Attach that account and then do whatever you feel like. Then you, when your department stops working, you can't get any amount anywhere. Then you'll have be bound to pay them. Get the head of the account. We'll attach. Oh, the heads are here, na? Why do we do it? We have the heads. Yes, head of account is here. 207000105471927927 so and so. This is the head of the account. We'll attach this head of. Give time till Monday. Pay or attach. Whichever you feel like.
By
Mr. E.W. The learned counsel appearing on behalf of the respondent contemptor submits that on 11th of November, submits on an instruction being issued on 11th of November 2024 that the financial sanction have already been made by the General Administration Department for payment of the amount of rupees 3 lakhs. However, the matter is pending before the Finance Department for issuance of necessary sealing by its sealing proposal number BE-09-0050 and P-09-0051 dated 1/10/2024. It was been also mentioned that on receipt of the sealing from the Finance Department, payment will be released to the beneficiary's account directly through the DBT. Full stop. Taking into account the above, this matter on 25th of November 2024, on which date the council shall apprise this court as to whether the amounts have been already disbursed to the petitioner. Full stop. It is made clear that as there are specific directions for compliance, delay in disposal, the delay in releasing the financials, the sealing, delay in the dispersal would amount to would result in would be seriously viewed. The instructions is placed on record and marked as an action. Give an update. We already have the head of it. Get the money, wait, sealing is being done.
For hearing,
was recorded as
item
3 lakhs,
14.
could be 9 lakhs.
Huh?
Was recorded as 3 lakhs, could be 9 lakhs.
Three petitions, my lord, 3 lakh each.
I mentioned it. In one order, it will be there for them. You want 3 orders?
Item 14,
You want 3 orders for 3 matters?
No. This communication speaks 9.
Have you understood what
Yeah.
order I have passed? Convey no. Yes, what is this? Yes, where is Mr. NNB Chaudhary? Am I appointed him as an amicus? He's nowhere to be seen. What is wrong with him? No, we change him now. You have filed the affidavit.
Yes, ma'am. I will annexing those documents, including the inquiry report by the. And also one aspect, my lord, which was not known to us earlier. Paragraph 5 of our Yes, 35. Very pertinent question that why this document charge for documents in the association. We found that earlier, the partial reports were 16 feet for the.
Yes, yes, Mr. B. Islam. What is this type of cases? Why have you concealed that you have received 3 lakhs?
My lord,
You have already received 3 lakhs.
my lord,
An amount has already been directed and paid. Thank goodness.
whisper.
We impose a cost upon you, the lawyer, for fraudulently filing this petition. I don't know about your client, but I'm going to impose a cost upon you. What are these type of things? You have already received the 3 lakhs.
2000 in the year 2016, madam.
So you must have forgotten.
No, madam. 2016, madam, it was filed for the.
You got the money in 2018. Then why haven't you done anything?
Yes.
You should have informed the court that I will receive 3 lakhs in respect to another matter where PIL has been filed. Not done.
That was.
Therefore, Mr. Chaudhary, your assistance may not be called here because taking into account the petitioner has suppressed certain things which were not brought to the notice. Yes. We imposed the 3 lakhs amount of cost upon him, not the petitioner, him, which he will deposit in the registry, which shall be used for the benefit of all the lawyers. Upon you.
That was received by the petitioner.
No, forget about the petitioner. You have not done it.
That was given by the commandant from the jail directly. And he was
Mr. B. Islam, heard Mr. B. Islam, the learned counsel appearing on behalf of the petitioner, Mr. B. J. Talukdar, the learned counsel appears on behalf of the respond number 1, 2, and 3, and Mr. NLB Chaudhary, the learned counsel and the learned amicus curiae is present. The instant writ petition was filed by the petitioner, who is the wife of
the deceased man.
Wife of the one Manik Ali, since deceased. And the instant writ petition was filed seeking compensation from the petitioner, from the state, on account of the death of her husband at Nagaon jail. Nagaon. It is seen from the additional affidavit filed on 5/11/2024 that pursuant to an order passed by the Learned Division Bench dated 16/3/2018 in PIL Sumoto number 6/2017, an amount of rupees 3 lakhs have already been paid to the petitioner and which was credited on 19/1/2019. So, taking into account that the said amount had already been paid by the Learned Division Bench of this court in PIL Sumoto number 6/2017, nothing further remains in the instant petition, for which the instant petition stands closed.
Item 15. Actually, that amount was claimed by the petitioner was rupees at the rupees 21,56,000. That is why in the year 2019, 3 lakhs paid, but the rest, that amount was.
Then why didn't you mention before the court that you have already got 3 lakhs by filing an affidavit? Yes, what is this?
Before start the seminar also. 3 days time to visit.
Okay, no problem. 3 days.
I'm not one.
What is the matter about?
Regarding the promotion, my lord.
Huh?
Promotion, my lord.
Promotion? What promotion?
Due to adverse remark in his, my lord, ACR,
Huh.
he was considered as not considered for promotion at that relevant point of time, my lord. And
And?
now he has retired, my lord.
Then what do you mean?
So, it should be there, my lord.
Why did you file the petition in the year 2013? 13, you have retired. After retirement, why did you file it?
My lord, before that we have been to my lord, the Assam Administrative Tribunal.
So what?
My lord, then my lord,
After retiring, why did you file it?
my lord, they are challenging that order passed by the, my lord, we have been here, my lord.
Sorry, where is the order of the administrative tribunal? You filed it in good. Mr. Counsel, administrative order is of 27, 2013.
My lord.
Then, immediately thereupon you came. You filed the AR on 2012. You were made, the ACR adverse remarks were made in the year 2002, 2003, and 2005, they say by the reviewing and accepting consequent, the appellant was not promoted.
Then, my lord, subsequently, my lord, we have to approach this honorable court earlier, my lord. And this honorable court has directed to, my lord, consider our case. That has not been considered, then actually, against that, my lord, we have been to, my lord, the
So what is your case?
my case is that, my lord, in the year 2002 and 2003, my lord, initially I was appointed as Inspector of Factories in the year on 1911, 12, 2080. The 1980, my lord. Then, my lord, in the graduation list, my lord, my serial is at 11, my lord. Then, my lord, by notification dated, my lord, 15/7/90, my lord, my service has been confirmed. And, my lord, in the year 1996, I was, my lord, suspended
And subsequently in the year, my lord, same year in the last portion, my lord, I was again reinstated. No departmental proceeding has been initiated, my lord. But then also in that process, my lord, the promotion from the post of inspector to the senior inspector has been, my lord, initiated. And my case was considered kept under seal cover. Seal cover at that point in 1996, my lord. Then, my lord, although, my lord, no departmental proceeding has been initiated against me, and I have been but that seal cover has never been opened, and the junior to me has been promoted for me, my lord. And my lord,
This happened when?
that part has gone, my lord,
This happened when?
in 1996, my lord.
Oh.
My lord, thereafter, my lord, in the year 2000, again, my lord, in the for the later on, my lord, I was promoted to the, my lord, post of senior inspector. And after that, my lord, in the year, my lord, 2007, my lord, another graduation list has been made for promotion to the post of, my lord, additional chief inspector of factories. Yeah, good. Then, my lord, when my lord, this DPC has been held, my lord, at that even an extract of, my lord, the ACRs of 2002-3 and 5-6 has been handed over to me, stating that the ACRs of 2002-3 and 5-6 are bad. That has been given to me in the year 2007. Immediately, I have given a representation to expunge the bad remarks. All other remarks have been expunged except one that I am submitted to my senior. That remains in both the ACRs. And remaining that, my lord, I have again submitted representation to expunge that, my lord. And later on, my lord, I have filed a petition before the honorable court. This honorable court, my lord, by the order dated 27/2009, my lord, is directed to consider me as case
For promotion.
to the post of, my lord, additional superior. And finally, that
If these don't at all say anything about the expunging of your remarks,
regarding that, my lord, this court has made an observation that these observations are in default. The respondent of the question is judged by the above imperative ACR's rules.
where you are reading from?
Case number, my lord, 157, my lord, the judgment. This is the annexure 32, my lord, starts at page 131. Yes,
157,
my lord.
please say.
There are 12. Disbursement. Because provisions of the ACR rules, they are ambiguously promulgate the obligations of the concerned authorities not only to communicate the advancement recorded in the ACR of an employee within the time frame fixed, but also to dispose of any representative made against the same within the period prescribed. It is no longer res judicata that the underlying objective of the communicating an adverse remark to the employee in time is to equate the efficiencies in his performance at the earliest, so as to provide him a scope to rectify his failings and commissions not only to sustain his prospects for further advancement in the career, but also to foster administrative efficiency in overall public interest. So a timely action on the part of the authorities concerned is not only a wholesome obligation on their part, but also ensures transparency in state action catering to good governance. The respondent authorities in the instant case judged by the above imperatives of the ACR rules have been clearly in default vis-a-vis adverse remarks reported in the ACR of the year 2002, 3, and 5, 6, effectively have contributed to the rejection of the any data of the procedure for the promotion to the post of additional civil inspector of factory on 27 to 2008. Certain respondents possibly appear to have remained not in regard for the petitioner ACRs of the year 2007, 8, 9 as well. So he has been graded good by the reviewing and inspection authority for his period 6, 7. He has been rented it below average by the reporting officer authority as well as the reviewing authority for the period of 78 and the period ending 2009. The accepting authority is the Commissioner Secretary to the Government of Assam Labor and Employment and Tribe Welfare Department for both the year, however, has observed that the negative remarks recorded in this are not acceptable as proof are not supported by documents and appear to be based on biased opinion. However, this authority has rated this prisoner as a forest. It passes one offense, a hands up as to how the prisoner could be rated as a forest by the accepting authority. The negative remarks bearing on its performance and other relevant aspects of personnel as recording by the reporting officer as well as the water has been dismissed as being not supported by any document and is found to be a bias. Going down from the reading below average to average above images cannot be considered.
Now, tell me, after that, where is the vacancy? Where is the vacancy? Has any vacancy arisen thereafter?
Matlab at that
after
point
the
of time,
judgment
matlab, 3 vacancies were there. At that point of time, 3 vacancies were there, and 2 have been promoted, and I.
At that point of time, after this exercise is over, the petitioner's case, if a vacancy arises as on the date, as the post of additional area would be considered along with other eligible candidates.
No.
Now, when did the vacancy arise?
Matlab vacancy,
The judgment was pronounced on
matlab 9. Vacancy arises on 2010, madam.
2009. Okay, show me when the vacancy arose. Thousand ten.
2010.
Your name is what?
Tuesday, Satya. Udayjiti Satya.
Huh?
Tuesday, Neeraj Bharali.
Your name is Neeraj Bharali.
Madam, my name is Tuesday Satya.
Ah, that I know. I'm
It is
saying
not-
about.
Disciplinary is Neeraj Bharali.
Neeraj. Thereafter, you submitted your representation.
Well,
After the judgment. After the judgment, did they communicate to you?
my lord, after the judgment, my lord, they have rejected my lord, prayer, my lord.
Huh?
They have rejected my case for promotion, my lord.
No. See, as per the judgment of Justice Roy, kindly see page 159.
Yeah.
On a totality of the consideration is above, this petition is disposed of with the direction to so and so to forthwith communicate to the petitioner the contents of the ACR for the period from 1/4/2007 to 31/3/2008 and the period ending for 28/3/2009.
Lord.
If the petitioner submits his representation against the same, those would be duly considered in accordance with the ACR rules and regulations be communicated to him without delay. Now, was there any communication to you for this period?
Well, thereafter, I have submitted representation as per direction of this.
For which?
For considering my case.
Which period?
My lord, immediately after passing this, my lord.
Which period? You are submitted your representation for which period?
My lord, 2000, after, for this, my lord, 2019, my lord.
Show me that.
Yes, submit. In this judgment of the Lordship, order of Lordship, respondent has considered his name Lordship as a zone of consideration. His name was in number 1 Lordship as per our affidavit stated. But his name was not considered into advance remark for the period of 2002 and 3 and 2005 and 6 Lordship. His name is not considered. Para
The
25.
ordinance do as regard 2000, you say it is bad, then
Lordship, as per the judgment of this order, Lordship,
longer the underlying dispute. Now kindly come to page 158. Notice it. The petitioner has not been aware of the grading awarded by the accepting for these periods. This assumes importance in view of the fact that at the time of consideration of the petitioner's efforts for promotion to the post of additional chief inspector of factory, if otherwise qualified, therefore, the ACRs amongst others for the period from so and so would be assured to be taken off. This court is of opinion that having regard to the background of the facts and the relevance of the ACRs for these periods of for promotion, the same ought to be communicated to you so that he advised in submitting representation whereupon those be considered by the concerned state authorities so that he may get have any grievance of having been denied a timely communication. So the adverse remarks which were there in 2002, 3, and 6 and 7, not
5, 6.
5, 6,
5, 6.
have not, although the court said many things, but did not interfere. He was asked to submit a representation. Now, did he submit a representation?
Lordship, as per this submission of representation, Lordship, his name is considered, Lordship. And kindly have a look, Lordship.
Where is his
in opposition, Lordship? It was filed by the 1 and 3. As per number 1 and 3. Para 25.
Huh?
In our affidavit in opposition, Lordship, it is filed by respondent number 1 and 2, Lordship. Have a look. Look, para number 25, Lordship. Para number 20. May I read, Lordship? That with regard to the statement made in paragraph 35, 36, and 37 of the writ petition, the deponent admitted the fact and further states that as per court's order in WPC number 854/8, the Sri Orali was considered for promotion in the TPC meeting dated 25/6/10, and he was number 1 in the zone of consideration. But since some of the adverse remarks for the period 2002 and 3 and 2005 and 6 were retained, the committee was unable to consider his promotion. And against the representation, the principal secretary note the annex 16 to the chief secretary.
Now tell me, for the purpose of filling up the post in the year 2010, consider the ACRs of which year?
Better to Lordship, day after tomorrow, please, the matter day after tomorrow.
Right.
I have not gone to the case, Lordship.
I have also not gone.
Day after tomorrow, Lordship. Day after tomorrow, Lordship. 3 years consider. It was considered for
How
last year.
you taking it from the ACR of 2002?
Better to, if the matter day after tomorrow, but I have not gone to the case. Absolutely. Then tomorrow, Lordship. Then tomorrow.
Not tomorrow. So, you think the court has no other way of,
I understand.
you see, giving you so much of time
No,
and
no,
they-
I understand.
Show me the rules. How did you take care of 2006, 7? It's a very relevant concept.
they could have communicated me this, the adverse remarks to me within 1 month from the,
Mister, where is the rules?
so this is, there are some service confidential rules.
Where? The council, if the court is trying to help you, kindly help this court to. Are you going to keep it with yourself or give it to me? Why are you going into this? I'm asking about what is the service rules?
Well, the factor
What is the service rules? Why are you not concerned with the ACR?
factor,
This is the service rule.
the factory service.
Huh? Read this. So you can take into account many other aspects. In spite of that, 2002, 3. This is the period which has been taken.
2, 3 and 5.
2, 3, 1, 4, 2002 to 25, 8, 2002 and 26, 8, 2002 to 31, 3, 2003. Can the board take into consideration those aspects in the year 2010? Any adverse entry? If somebody does anything 10 years or 8 years or 9 years back, when the court has already held that this was not properly done, there is a default.
It can have tomorrow works. Tomorrow works as a part. Two parts.
How is it possible? Your rules are also, I think, of 1800s. And British was the big. Too vague rules. The government now is the welfare organization. They should do something better. Point my time. The council, it is very difficult. Get a slot for doing the matter. Question arises is simple. Can you take into consideration after the observations were made by the learned civil judge? One, in respect to the adverse marks of 2006, as well as subsequently in the year 2010, that too, when the earlier periods there's no such adverse marks. The 4-5, 2007 and 2008, there was no problem out there. He was above average. So there was nothing out there. So that which was there, can you still only well coming fasting. Thursday not tomorrow. 5:30. Not 5:30 in the evening. Yes, 5:30. Can be before. It's the matter tomorrow. It's the matter tomorrow. The last item is the public.
Look, the petitioner herein has challenged his penalty of dismissal, my lord, the order of dismissal, which is dated 26/8/2015. Now, my lord, this order of penalty dismissal is an outcome of a review, my lord, of a suo motu review of the initial order passed by the disciplinary authority. My lord, I'll very briefly give a background, my lord. The petitioner, while he was working as a superintendent engineer in ONGC in the year 2011, was issued a charge memo, my lord, for some purported misconduct. My lord. He, along with some other delinquent employees, were issued similar charge sheets, my lord, and thereafter the disciplinary proceedings were initiated against the petitioner. My lord, after the inquiry was conducted, my lord, the petitioner was initially issued a penalty, my lord, the first order of penalty, which was issued by the disciplinary authority, which my lord would find at Annexure M, page 112, which is dated 12/9/2014. After consideration of all the materials which are available, disciplinary authority came to a decision that he should be imposed a penalty, a major penalty of reduction of 2 scale, lower in time scale for 2 years. Now, my lords, pursuant to the imposition of penalty, the petitioner took a conscious decision that he would not challenge the order of penalty, and he chose not to prefer an appeal and move on with the penalty. So the penalty had also taken effect. Thereafter, my lords, all of a sudden, on 9/3/2015, my lords, may kindly take note of the date, my lords, 9/3/2015, that is exactly 5 months, 25 days after the imposition of penalty, the order was issued by the authority. As per the order, my lords, it was the petitioner was placed under suspension in contemplation of review proceedings. And it was informed, my lord, that a review would be initiated against me. If my lord kindly takes up page 114, my lord, for me, the order, my lord, 114 minutes. 114 minutes. I'll read it out, my lord. Whereas the RKN of superintendent engineer so and so was charge sheeted in 2 cases. So
Where is the power of review?
my lord, 54.
Did we get it?
54, my lord, the CBA rules are available. Okay. 54. Review by the reviewing authority. And the CBA rules are available. The ONGC conduct discipline and appeal rules 94. That is the other thing. And it's also quoted in the writ petition. But the rules would be necessary. With a copy, my lord. My lord, I may kindly request my lords to take up, my lord, the rule 36 first, my lord, before my lord takes up. Moment. My lord kindly takes up rule 36. You know, 36 is the rule, my lord, which prescribes the methodology of imposing a penalty, my lord, the disciplinary proceeding. Like rule 9 of the CCS rules, my lord. It's akin, my lord, to rule 9, 36. I'm referring just to drive in a point, my lord. Procedure for imposing major penalty. My lord would come to 3 first, 36(3), where it is proposed to hold an inquiry against an employee under this rule and rule 37, the disciplinary authority shall draw up or cause to be drawn up A, substance of imputation, B, statement of imputation of misconduct, and my lord, there are additional grounds, my lord. In terms of rule 36(3), my lord, a memorandum of charge is issued, my lord, a charge memo. When disciplinary proceeding is contemplated,
Your point is this. Passing of an order on 9/3/2000 cannot be considered to be order of execution.
Yes.
Execution is only right up to 6 months. But initiation happened after 190 days, so yes, it is beyond the period.
I say so, my lord, with all due respect, my lord. I was referring to Rule 36, my lord. 36 is the methodology of imposing a penalty pursuant to disciplinary proceeding. And it can be inferred from Rule 3 that it is only when a charge sheet is served on a delinquent employee, I'll place judgments for that. Only when a charge sheet is placed upon a delinquent employee, the disciplinary proceeding would initiate. Now, similarly, my lord, if my lord reads Rule 54, it says, my lord, the subclause 2, I may kindly read it out, my lord. It says no proceeding for revision shall be commenced until the proviso, I'm so sorry, my lord, provided that no action under this rule shall be initiated more than 6 months after the date of the order. Now, my lord, with all due respect, my lord, the dictionary meaning of the word initiate means to commence or to begin something. And my lord, my lord is aware, my lord, the review has to be derived from the statute. It's not inherent, my lord. So the power is there. They can review. But there is a proviso, my lord, which says it has to be initiated more than 6 months. Now, if my lord reads the rule further, what can be inferred from the rules, my lord? In my humble submission, my lord, there's an explanatory note, my lord, which says no order imposing or enhancing any penalty shall be made by the reviewing authority unless the employee concerned has been given a reasonable opportunity of making a representation. Now, if the entire rule is read together, it can be inferred, my lord. It is only when I'm given a reasonable opportunity to represent, only then the review would initiate, my lord. Now, one more thing, my lord, if my lord takes up the order which my learned senior friend claims to be the initiation, my lord, I'll just read one paragraph. Page number 2. I'm so sorry. Page number 114. Just for a moment. Yes. Well, the third paragraph. Well, this is akin to an order of suspension which is issued in contemplation of a disciplinary proceeding. Third paragraph. Whereas the CMD, as the reviewing authority, in exercise of powers vested under him under Rule 54, IBET, has decided to review the penalty imposed on Sri Nyog and place him under suspension with immediate effect. Now, this means, my lord, there's a decision. No, yes, they have decided that they are contemplating that we would review, and therefore we are placing you under suspension. Now, my lord, if Rule 50,
has decided.
if Rule 54 is construed, my lord, in totality, my lord, harmonious reading, if a decision won't do, my lord. A decision is different from that of initiation, my lord. It is not on the same line, my lord. The authority can decide to review.
What does black say?
Yes, I placed it, my lord. Ramanatha here, not black. Yes. The word initiate means an introductory step or action, a first move, beginning, start, and to initiate meaning to commence. So it has to commence. Now, when will it commence? Only when I'm given an opportunity and thereafter I reply. And thereafter they can decide not to review also. If my reply is found to be satisfactory, they may not go ahead with the review. Now, initiation does not mean decision. decision would be different. They may decide at whatever point, my lord, but it has to be, my lord, Lordship may kindly take up this Ramanatha here. If my lord kindly takes up rule 33 for a moment. Look, the order dated 9/3/15 is totally, my lords, akin to an order whereby a delinquent employee is placed under suspension in contemplation of disciplinary proceedings. And the law is very clear in that regard, my lord. It is no longer res integra that when you place someone under suspension in contemplation of disciplinary proceeding, the disciplinary proceeding does not initiate. Even at that point of time, there is a decision. And that can also be inferred from the rule itself, my lord, from the explanation. How will it initiate? My lord, RL Kapoor, my lord, Rajinder Lal. Here, my lord, actually what had happened, my lord, the charge sheet was issued after the person had superannuated. And there was this contention, my lord, that the disciplinary proceeding would only initiate when the charge sheet would be served. My lord may come take up the relevant paragraph, my lord, paragraph 21. May I read it? May I read it? Yes. My lord, it is clearly stated, my lord, it is disciplinary proceeding is initiated only when a charge sheet is issued. Because that is in terms with the rules. Like I have shown rule 36, my lord. Page, yes. 70.
This aspect of the matter has been considered by this court recently. This went through well. The date of application of mine on the allegation leveled against the officer by the competent authority as a result whereof a charge sheet is issued. The date on which disciplinary proceedings state to have been initiated, not prior thereto.
It says, my lord, it is initiated only when a charge sheet is issued. See Union of India versus KB Janakinam.
Thereof,
This aspect of the matter has also been considered by this court recently in Coal India Limited versus Saroj Kumar Mishra, wherein it was held that the date of application of mine on the allegations leveled against an officer by the competent authority as a result whereof a charge sheet is issued would be the date on which the disciplinary proceedings are said to have been initiated, not prior date. So charge sheet has to be issued. Now, in this case, my lord, because there was illegality in issuance of the charge sheet. They had quashed the charge sheet, and what was the relief granted? My lord may kindly see, my lord, paragraph 28 and 29. We direct the appellant to pay all retirable benefits to the respondent expeditiously. The appeal is dismissed. So all retirement benefits were directed to be paid in this case because when the matter was filed, the petitioner or the appellant had already retired. Now, my lord, I'm saying on the last occasion, my lord, the word initiate was also discussed by the Honorable Supreme Court with regard to contents of Courts Act, my lord, wherein the Supreme Court had held, my lord, that it would only initiate, quo moto contempt would only initiate when there will be a show cause notice issued. That I have already placed, my lord. Now, my lord, if the entire rules. Now, my lord, may kindly come to rule 33 for a moment, my lord. I would show how the order of suspension also, my lord, 9/3/2015 is dehors or ultra virus D rules, my lord. My lord comes to rule 33 for a moment.
see, there's a fundamental difference between initiation of a departmental proceedings for a review.
Yes.
Say that you don't pass a decision and hence the penalty without hearing. Where 36 say that if you want to impose any of the legal penalties, you have to go for an hearing.
Yes.
And thereupon, you have to lay down the charge sheet and all this thing.
When it is proposed to hold an inquiry,
So
then
therefore,
you charge sheet.
no, therefore, actually, to hold an inquiry is another aspect. We see the explanation, no. It does not say about holding open inquiry. It says that while reviewing is given an opportunity of hearing before
Exactly. Understood.
even if there is a fundamental difference between
Yes. I'll try and I'll show the similarity, my lord. Because in case of a review, my lord, with all due respect, my lord, holding of an inquiry does not come into the picture at all. Because the inquiry has already been held. Now, it is on the basis of the records already available with the appellate authority, you would decide whether to review or not to review. Now, in 36, when they propose to hold an inquiry, it is incumbent, although it is not stated in express words like 54, it says, my lords, that if you want to propose to hold an inquiry, you have to substance of imputation of misconduct, statement of imputation of misconduct has to be furnished to the, which is normally we call it as the charge sheet. So that has also been held.
there might be a case.
Yes.
May not even notice that here, but in hearing that okay, now we find out what you there might be a case where you may say that, okay, where is the question of writing or giving us a reply to the affair? I feel that this enhancement should be there. So what do you have to say?
Not unilateral, because if my lord reads the show cause notice, it gives me an opportunity and yes,
It is a different thing,
Yes.
but you see, we are trying to interpret whether application of mind to revise the order, although they have put the word reviewed, later on they themselves say it's more like a power of revision. To revise the order would mean initiation, or whether there is a requirement of following an inquiry by giving him a notice of hearing. Because what it says that you can't take a decision for the purpose of imposing a penalty or enhancing the penalty without giving him an opportunity of hearing. How do you say that it is a case of similar to 36? 36 is a different thing. If you want to impose a penalty, you have to go for an inquiry. Major penalty inquiry is a must. It is same like the rule 9 of the Assam Disciplinary Rules. So you have to hold the inquiry and then only you can do so. Now, inquiry stipulates many aspects. The first of such aspect would be that I have to frame the charge sheet and give it to him.
on the charge.
And these are the charges on which we are going to initiate the proceedings against you. Now, if you go to the CCS rules, even prior to that charge sheet, another hearing is conceptualized by issuance of a notice. So whether this particular judgment would be applicable in such circumstances is another aspect. Because in those CCS rules, first you will be heard as to whether these are the things which you have found, should we go for an inquiry? And thereupon it is taken upon and decided on the basis of that, yes, we go ahead. Then you say that, okay, these are the charges which are framed, now go ahead.
Insofar as preliminary inquiry is concerned, that has already been settled by the Honorable Supreme Court. That preliminary inquiry won't do until and unless there is a formal charge sheet in terms of the rules. The disciplinary proceeding would not initiate. Now, in my humble submission, my lord, Rule 54 does not envisage, because they use the word initiate. Had they used the word to intimate or to take a decision now, my lord, why that period of 6 months is there? The rationale behind it is, my lord, that the delinquent person should not be kept under the threat of his penalty being reviewed or enhanced for an undetermined time. My lord. Now, my lord, there can be a situation, my lord, the authority decides, they decide, okay, we will review your penalty and will enhance it. And they just inform me and place me under suspension, which itself is rehearsed the rules. I'll come to that, my lord. And thereafter, they do not issue the show cause notice for another 5 years. In that case, my lord, will the limitation of 6 months get enhanced for another 5 years, my lord? That is the reason why, my lords, they have used the word initiate. And my lord, I have shown from the dictionary, since the word initiate means to commence or to begin. Now, my lord would take a call from the order of suspension. Does it initiate any proceedings against me? Proceedings has to be initiated. Merely information would not suffice, with all due respect, my lord. It has to be initiated. And how is it initiated, my lord? In all cases in service jurisprudence, my lord, it is only when a person is show caused or a charge sheet in terms of in cases of disciplinary proceeding is issued, my lord. Now they had suspended me from the tenor of the order of suspension. It would show that they had not initiated till then. They have suspended me in contemplation that they would initiate review proceeding for you. Now, if my lord may kindly come to Rule 33 for a moment, my lord. I'll not take long, my lord. 33. My lord has it, my lord. Suspension. the appointing authority or any other authority to which it is subordinate, or the disciplinary authority or any other authority empowered by the company by general or special order impose a penalty as specified in so and so, may place an employee under suspension. A, where disciplinary proceeding against him is contemplated or pending, where in the opinion of the authority aforesaid, he has engaged himself in activities prejudicial to the interest or the security of the state, where a case against him in respect of any criminal offense is under investigation or trial. And two deals with my lord's deemed suspension, rapidly, my lords. We're not concerned with two. Now, my lord's suspension, my lord is aware, there cannot be the power of suspension has to be derived from the rules. Does 33 provide for suspension in contemplation of review? Even 54 does not provide that if you want to review or initiate review proceeding, you can place me under suspension. Suspension can only be in terms of the rules. So in terms of 33, there is no provision whereby an employee can be placed under suspension in contemplation of a review proceeding.
Or pending,
My lord,
or pending,
or
pending.
my lord, right.
Is it pending or is pending?
Or it's pending.
Then
It's not pending, my lord, because it's not because not
if
been
it has
initiated.
already, if we take it that taking a decision amounts to initiation, what the purpose of 54? It will be pending,
In that
and
case,
taking into account that the revisional, it is more like akin to an appellate jurisdiction. An appeal may not have been filed, but it is akin to the appellate jurisdiction, which is given in the explanation. An appeal being a continuation of the proceeding.
it is pending, my lord.
Okay,
There
okay,
is
take your
something
seat.
anterior to
Yes, Mr. Sahiwala, what do you have to say?
the other point I'll write later. Clarity.
When? How do you initiate? But do you say, how can you say it to be initiation? How can you say a review proceedings have been initiated? Now, tomorrow, just for example, I take a decision, okay, that this I am going to dismiss the petition of the petitioner. And tomorrow you are going to throw him out. I have not passed the order itself. It is only the conception is being thought that we are going to go and review it. How do you take care of that? How do you say that to be initiation? If it is a case of 54, initiate would mean something by which a notice has been issued. Huh? Would it make a difference? Is it different from 114? I've gone through the representations stated when prepared by CJ, and so it is observed that the representations have been addressed to the chairman for each of the appeal Why is it slashed from 10 to 28? Huh? But please put up the action taken report by 28. So what you did is you issued the notice on 28. Your officers did. Who issued the notice? On 20. Why didn't you issue the notice earlier? You have taken a decision. I exercised my power of review under 54. But this order has not been informed to him that you have already exercised the power of review. That you have already exercised the power of review is not been informed to him.
Exercise the power.
Also see if the records were called for, my lord, because 54, and we suggest that records have to be called only then a decision, even if a decision. Well, it says the authority to which an appeal and order imposing any of the penalties specified in Rule 34, my lord, of its own motion or otherwise, call for the records of the case of the disciplinary proceeding, then review, my lord. So if a decision has been taken for review, even a decision, my lord, before that, the records has to be before the appellate authority. Like he has to call for the records. Only then he can take a decision.
No, he has already
Called.
had the records.
Yes.
Records are not there is not a question. But he said, therefore I exercised my power of review under Rule 54 of the CDA rules and proposed to enhance penalties against so and so to dismissal from service of the ONGC. Accordingly, they should be issued a show cause as to why they have penalties should not be enhanced as proposed. I also direct the file FIR against the persons as advised by the chief so and so in his opinion in so and so.
In any case, my lord, only when the show cause is issued to initiate, it is up to them. They may have decided or exercised their power, but the 54 demands that it has to be initiated, my lord. Initiation has to be commencement and it has to be a show cause notice.
But Mr. Savanda, you could not have exercised the power of review. You could not have exercised the power of review without giving him a reasonable opportunity of hearing. So are you saying that you have exercised the power, now you are going to give him a reasonable opportunity of hearing? Yes. How? How will this be construed to be initiation of proceedings? No, he may say anything, but in legal parlance, can you say that keeping a decision to yourself and you not doing till 28, by which 6 months have elapsed, would that amount to initiation? Huh? How? No, here the word you did, no, while no action under this rule shall be initiated. So you are saying that taking a conscious decision amounts to an action of initiation.
Then after that, then they have to express only,
Why haven't you brought this aspect? Is it a part of your records? How is it frequently coming? Have you mentioned anything in your affidavit about this stuff? Then why should we take into account this? For the first time you are bringing it, why? You may have manufactured it now. There's not a single word order. You have all mentioned about 9(3). Then that the decision to review the case was initiated by the competent reviewing authority on 5/3/2015. That is well before the expiry of the year. So you mean to say, therefore, initiation of a review proceedings is a different aspect from taking any action under this rule, which was done within the period of 3 months, 6 months. Initiation of review is not the question. What is required to be done is take any action under the rule within 6 months. Kindly see, it doesn't say provided that no action under this rule shall be initiated more than 6 months after the date of the order. So therefore, any action taken within the period would amount to initiation, irrespective of notice have been issued on. The power to be exercised within 6 months is what is meant by the provider. Provider is for a suggestion. Initiation. Then suppose no order. That order is part of the. Bring this on record by filing an affidavit. So that we get a chance. During the course of the hearing, Mr. P. inside of the community in place document by the PMD of the ONGC. So taking into account the relevance, the scope is that the document be brought on record by filing an additional affidavit so that the petitioner can have a say document. This matter again, 25th of November, 6th of November. The affidavit, additional affidavit be filed by 20/0/11/2000. Petitioner if so agreed, filed will be at liberty to file in reply by 20.
Also the records with regard to the court delinquent, because I'm also on the ground of parity and I have urged my lord, the others were not.
The next is when you see the first if it is goes, then only the second comes, na?
Yes, yes. First, if I succeed, my lord, in case I succeed, my lord, the second.
Yes.
Deeply obliged, my lord.
Yes, Mr. Bhattapur, your matter. Others may go. I would not be sitting much because I have some other work, other matter to be looked into. It's Mr. Bhattapur.
I don't thought I kept it. 51. Lordship was released to Lordship. Any other day, something.
51.
51.
21, I fixed it to 2.
Last occasion,
What is the matter about?
relating to the declaration of the master rule worker lordship. Here,
Regularization of
master rule worker lordship in PWD department. Lordship he has worked for 3 years lordship. But his junior was regularized. In 2007 lordship, my records was referred to the government. And government has admitted that their position that my case was in process. But by virtue of 2012 notification, they are not processing. And last occasion, sorry, in earlier occasion, lordship, the honorable court by order dated 4/8/22, as well as uh 2/12/22. Relying, I referred the judgment of Prem Singh lordship, paragraph 36. And the
how
comment
can this for direct regularization?
not, my regularization is that lordship because I
Everything regularized? No.
not. Others were regularized. My case was on process. And subsequently, lordship, the earlier court, lordship, I referred the Prem Singh judgment of paragraph 36. And the government has asked to verify the said judgment about whether any other subsequent judgment. May I read just for time, 2 minutes, lordship, I will take. Adjourn on the prayer of P. Nayak Learned Council for PWD to make further some as to whether the provision rendered by the Supreme Court in paragraph 36 of the judgment rendered in Prem Singh versus State of Uttar and others reported 2019-10 SCC 516 had been viewed in a manner different by the Supreme Court in any other subsequent decision. And thereafter, lordship, the matter was so listed but could not reach lordship. So I pray lordship not today, subsequent, I will not discover any other day subject to convenience lordship.
Actually, I have to deliver a judgment, so I have to write a leave today.
Lordship, I am not, I am not disturbing
It is a
lordship.
CAB,
I am not disturbing, I only pray that
But
any
other
other day
days I
subject
rise
to
at 5
convenience.
o'clock. After making correction, use it around 8 o'clock and then go home. Don't get the time otherwise.
Lordship.
Even Saturday, Sundays.
Any other day subject to convenience, I will try to file my written submission, lordship, I will not take much time. Lordship. Any other day subject to convenience.
Take it up at 2 o'clock.
Tomorrow,
19, 2 o'clock.
19.
Yeah.
Sorry, lordship, I disturb lordship.
That's around 19 days. So whatever you have urgency in the matter,
Lordship, your lordship may fix any other day. Urgency in the sense, your lordship, they have been terminated from service, dismissed from service.
so
That
so
is the only-
urgency.
Your lordship may fix any other day.
Let's have it on 26th
Lordship,
2 p.m.
lordship. Twenty-eight.
One day, again, I'm not here for 2 weeks.
No.
First of we have to 13. Absolutely no. 28 is 20. How much adjournment you want? I've already given you 26. You return of 26 or 28. You can't stop everywhere.
Deeply.
Fantastic. Appear through video conferencing there. The matter here. Ask somebody else. We have got enough opportunity. This is for which department? Very sorry.
No, not the MC Hills Autonomous.
There are other councils. So the Kolkata matter won't happen.
Obliged.